Ms. Winkles is here, Mr. Hamir is here, and Ms. Smith is here. Let me just first say there's been a series of emails sent starting yesterday, and it looks like the majority of this case will be put over to May 25th.
Yes, Your Honor, that motion should be before you. There should also be an order. It's just this case is so old, I don't want to have all of them wait to the end. So I don't know what's going on with my video. Let me turn it off again. This is just for the date, I believe, up until December, maybe a little bit after that. And then I'll make the final motion, obviously, at the evidentiary hearing.
And then you were appointed by OP, Office of Public Defense, in this case.
I was, Your Honor. Yes, I've been on this case since 2021.
Anybody here on that case? Okay.
Your Honor, Sherry Farr, the court visitor. I do see Alonza's name, so maybe she's having trouble hearing.
Alonza Teft, are you with us?
Yeah, can you hear me?
Yes, now I can. Okay. And the immediate order was extended by Judge Evans, but I believe you brought a motion to release Annabelle as personal property. Is that correct?
Yes, because Michael's keeping all her clothes from her, and it's been a struggle trying to get her outfits and having to buy her outfits from Walmart every day for her to have clothes to wear to school.
Where are these personal items right now?
They're in Michael's car, the car that Michael's sleeping in.
All right. So if I order that they be delivered, how do you see that happening?
I would just have to give him a copy of the court order or have somebody serve him and then have him deliver it. He'll deliver it once he sees the court order, I would think.
Okay. Is Michael Teft here? I don't see him. All right, I will do a bench order that he needs to deliver Annabelle's personal items to you. I'll say he needs to do that by Monday.
Thank you, Your Honor.
You can pick that order up sometime tomorrow from the clerk's office, and we'll see what happens. I think if he doesn't do it, what I would do is wait for the trial date on the 15th and then bring that to the attention of the court at that time.
And
Okay, also,
I think the child should not be present at that exchange.
Okay. I will add that to the order then. Okay. Thank you, Ms. Teft.
Thank you.
And who else is on that case? Mr. South, are you on that case?
No, Your Honor.
Okay.
Ms. Cannoni, she's present.
Oh, there we go. Okay.
Amy Powers for the state of Washington.
So it looks like we have a hearing already set on May 9th. And I guess a couple questions. Ms. Farr, can you tell us where you're at on your report in this case? And then I've got one more question.
Okay. I wasn't prepared to answer that.
Sorry.
It's okay. Let me just look real quick. The reason that this hearing was scheduled was because Your Honor directed that Ms. Cannoni filed the emergency petition so that she would have some authority while so we could get an immediate order in place while the standard petition is going on. And so that's just been done. And so now that's going to have to be served.
Right.
So I think we're just waiting for procedural stuff to be completed so that I can get my report completed.
Okay. Ms. Cannoni, I saw you filed for the immediate emergency order. And is that being served on the parents? You know?
It will be. I've got to get with Ms. Farr to figure out how to serve the father in prison. And then I am trying to go through people to get the mother served, as I think they know where she's at right now. And she's up in, oh gosh, past Woodland, way up past there. I can't remember what town she's in. She's staying in a trailer up there somewhere.
All right. So you'll work with Ms. Farr on that. I had set a hearing on May 9th, I think, to make sure the immediate was filed. And then this hearing came up because after you file it, there needs to be a hearing within a certain period of time. do we still need that hearing, or should I put that out a little ways? This far, I guess I'll ask you.
I think we could keep that hearing to, well, that's only a week away, 2 weeks away. We probably should put it out a little bit so that they can get served and have the response time, so that we can enter at least the emergency order at that point, if you are entering the immediate order today.
And I see I set it on May 9th, which is a Tuesday. It probably should be set on Thursday.
Okay,
What I'm inclined to do is put the next hearing out to May 25th. Strike the hearing on the 9th.
okay,
And I'll extend the immediate emergency order until the 25th.
okay. You mean enter one, because we don't have one yet.
Oh, I thought the court did. I guess not.
That's why she filed the petition.
Okay, sure. I'll do the immediate emergency order
Mhm.
through May 25th.
Okay, that gives time for the 20 days response, and then we could potentially enter the emergency order at that point.
Okay, very good. Do I need to appoint you a GAL in the emergency proceeding?
I believe you probably do.
Okay, I'll take care of that then.
Okay, thank you.
All right, so Ms. Chianoni, Ms. Farr will be assisting you in getting everybody served. And the next time we'll be back here will be Thursday, May 25th at 10:30, okay? And
Okay, thank you very much.
we got Kristen Masters. Is Joanna Carroll here or Ronald Carroll? I see Travis Masters. Oh, there we are, Joanna Carroll. Okay, good. So this is comes up actually a little bit unusual, but it's the parents petitioning to have the Carrolls appointed at this point a full guardian of their children. And I think both parents are here. And if you understand that, if I agree to that, that guardianship will not go away unless there's a motion to release the guardian at some point in the future. Are you comfortable with that?
Yes.
Okay. Joanna Carroll, you're comfortable being the guardian in this case?
Yes,
you're-
I'm definitely okay with that.
Okay. All right. I will agree to it. Looks like everybody's in agreement.
Thank you.
Thank you.
All right. The order that we were given was for an emergency minor guardianship. The petition, though, was for a full guardianship. So could somebody put together another order that would be for a full guardianship?
I believe I filed one. I filed both of them. I'm not sure. I can make another one if you wish.
We're checking our records here.
Very well.
We just have one for an emergency, and I don't think that's what you're asking for. So if you could do another one, submit it to the attention of Commissioner Dave Nelson, and it will get to me and I'll sign it when I get it.
Okay, very well.
Thank you.
All right, thank you. Anybody
you.
on Maisie Alexander?
I'm here, Your Honor. Let me text Dawn if you want to come back to that in a few minutes. Let me see where she's at because I thought she would be here.
Okay, one of the questions when you talk to her is there was an order to serve the mother by mail, but I don't have a affidavit that was done.
Okay.
You might want to ask her about that so we can address that. McCoy, get back on. And I think
Okay,
I
thank
saw Kendra Yasanovich here.
Yeah, I'm here and I see mom is here too, Tesla.
Okay.
And I think Mallory's here. Yeah, there she is.
The question, I guess, was, is the mother still in jail?
No, she's here. She's in rehab right now. Tesla, I think you're unmuted if you want to say hi.
Hi, Your Honor. I have
Okay.
I have 31 days sober today.
All right. And Ms. Smith, you're on this case. Have you had a chance to talk to the mother in this case?
I have not, Your Honor. I did send a letter to the last known address and attempted to make contact through a couple of social media profiles. I haven't had contact with mom yet. Ms. Jozanovich did indicate that she may be in rehab and unavailable. Tesla, if I could give you my phone number, it'd be great if we could have communication. Just to, Your Honor, just to give you a quick synopsis. And so I have spoken with Ms. Jozanovich. It was indicated that father had signed the consent for the guardianship. I don't see that it's been filed with the court yet. I have spoken with the petitioner and plan to meet with the children shortly and then have a supplemental or have the initial court visitor report to you. I don't know if the court would like to get perspective from the mother to see if she's in agreement with the guardianship. That would determine whether I should be discharged as a court visitor and maybe transition to a guardian ad litem role.
Ms. Ivy, what's your position on the guardianship?
Well, I'm doing whatever I can to, get my children back. I'm a single mom. I've been in addiction my whole life. I'm working on getting the help, and I'm serious about my recovery. I was just needing help with like funding, and maybe CPS can help us get a home. But I'm willing to do whatever it takes. Like I said, I have 31 days today, and I graduate treatment on the 17th of May. Like, my kids matter to me, and I'm not my addiction. So that's where I'm at with that.
Okay. Ms. Smith, sounds like Ms. Ivy may agree to at least the temporary or the emergency guardianship, but I think part of your court visitor duties would be to check with her and determine if she understands that and would agree to it. So,
I'm not willing to sign any paperwork. Those are my children.
all right.
Your Honor, I think the major problem here that Tesla's having is she's thinking she's signing the right to her children away. And I've tried to explain it to her. I think her mom's tried to explain it to her too. So maybe she needs a little bit more education on what this actually means, because I think she's really fearful that she's signing away her rights to her children forever. And that's not necessarily the case. Right now, they're doing really well. They're thriving. They're doing sports. They're just doing so amazing. I completely 100% applaud her for getting sober and the 31 days. That's so amazing. But this road to recovery and the road that she's going to continue down for a while, it shouldn't be a path that children go down with her. And I just think that right now they're really good here. So maybe a little bit more education on where or what her legalities are down the road if she agrees to the emergency or whatever we need to do. I would hate to see them get pulled away from an environment that they're thriving in right now.
Okay. Well, I'm going to ask that Ms. Smith meet with Ms. Ivy and explain those things to her. Okay. And we'll need to set another review date. And if the father is consenting, then he'll need to file a consent form.
Yeah, he did fine, and I do have that paperwork. I apologize. I had some medical issue come up, a tooth problem, and I just started a new job. So I'm going to actually head to the court as soon as we get off this and get that filed for you guys today.
Okay. And what's your name?
Mallory.
Okay. I had called the court before and they hadn't given me a name of an attorney or anything. So that's why I hadn't reached out to you.
Not a problem. Thank you.
Okay. We will set the next date then, Thursday, May 25th at 10:30. That will be on Zoom. All right. Just like I see that Ms. Spalding was served on April 21. The father is deceased. And you're requesting an emergency minor guardianship, which would be good for 60 days. And since there's no response from the mother today, I'm going to go ahead and grant that. I can extend that another 60 days after the first 60 days, but after 120 days, I can't extend that any farther. So if you believe a guardianship is necessary beyond that time, you need to petition for what's called a full guardianship and also serve that on Ms. Spalding. And then we'll have a hearing on that, or if she objects to it, we'll take care of setting that for trial.
Okay.
Do we have that? All right. My clerk tells me that I don't have an order on the emergency minor guardianship. Would you be able to put one together?
We have an immediate order and hearing at it,
yeah, so there's now, if you go to the court forms, you'll see an order for an emergency minor guardianship.
What's the form number for that?
I don't know the form number for that. I'm sorry. Thank you.
Okay, that was not in the list we were given, but okay, we can get that.
This whole listing, and it's not one of any of those. So 203.
All right. So 203, print that out, fill it out, and ask them to route it to Commissioner Dave Nelson.
Okay.
When I get it, I'll sign it.
Okay.
Thank you.
But if it needs to go beyond 120 days, you do need to get the other petition in. So one of the questions I had was there was an order to serve the mother by mail. And I don't know if that had been done. And if it has been, then we need a declaration saying that that's been done.
Yes, Your Honor. I thought I had filed one. She received it on April 8th.
Oh, that was a while ago.
But I can get one filed immediately.
Let me just look in the court file. I do not see a declaration that that was done. So if you could do that, that would be fine.
Yes, I can, Your Honor.
So, and also you'll need to serve the mother with the full guardianship petition, as well as the emergency one. Well, I think I granted the emergency. The next hearing, it looks like, is June 6th. And that's to determine if the, I think it's to determine if the emergency guardianship needs to be extended. June 6th. Ms. Day, any comment?
So my only comment was, it was my understanding that the June 6th hearing was only if the emergency was still needed. If Dawn has served mother with the full guardianship, then today was supposed to be entry of that order, but maybe that's my confusion. So that's why, not sure.
That
Actually, I'm sorry. She was, what I had served her with by mail was the permanent that she received April 8th.
okay. All right. I need to see some evidence that that was done, which is a declaration from you that you had sent it in the mail. And that's not in the file yet. If you can do that in the next couple of days, I could set this next week and probably enter the full guardianship at that time.
Okay, yes, I can actually do that today. Okay, that's great.
Thank you, Your Honor. I will be also submitting my declaration of fees so that the final orders can be prepared by Dawn and have those submitted hopefully at the same time. So I'll work with Dawn on that.
Okay, I'll be glad to take care of that then. So I'll see everybody on that case back. Are there any issues we need to address before we go to closing arguments?
Mr. Good Day, President, Your Honor.
I don't see Mr. Goodday.
I just emailed him a couple of minutes ago, Your Honor, to ask if he was going to be logging on. I didn't see a response.
Do you have his email address?
Yes, Your Honor. Let me get that. Josh at gooddaygeo.com.
And I had a different one. I'll have to find it here. I had a joshuahenry@gmail.com. I've reached him on that. I have both of them. Actually, it looks like he has even another one.
Okay. Let's go. It looks like we need him here. Although I'm not going to reschedule this hearing if I can't get him here. Let's take a 10-minute recess. I'm going to email him and see if we can get him here in 10 minutes. Okay.
I'll see if our office can reach him.
All right. We're back on the record on the guardianship of Hebding. And we're here for closing argument and then a decision by the court. Are there, I guess, let me ask again, are there any preliminary matters that I need to address before we go into argument?
Not that I'm aware of.
All right. So I'm going to first go to Linda Estolette and have her explain why she feels the guardianship needs to be entered. And then I think I'll go to Mr. Angelico, because I think his interest is to argue in favor of the guardianship. And then I'll go to Mr. South, who represents the father, and then to Mr. Goodday, who represents the mother. After that, because Ms. Estolette has the burden of proof, she'll have a chance to reply to what anybody else has said in this case. After that, I will make my ruling. Okay. All right. So Ms. Estolette, do you want to start us off?
Again, by saying that Gabriel and Celeste are thriving, safe, and comfortable in a loving, caring environment. Both are doing very well in school. They receive regular medical checkups and have dental checkups every 6 months. I wanted to clarify the issue of the braces. They are covered by our insurance, but only a percentage. We have copays and fees that go with that. An example would be on his April 11th appointment for Gabriel, I paid $300. And on the April 24th appointment, I paid $183. So there are fees that are incurred over and above what our insurance covers. We did not request child support because in the decade that Mr. Hebding was involved with my daughter, he was never employed. And given that the children are growing, there's an ongoing need for food, clothing, shoes, jackets, and so on. His current financial situation, driving delivery for what I think is part-time, hardly seems to be able to provide the resources that they're going to need. My daughter did send money when she was not in the home with us. She had received some pandemic stimulus checks, and she sent us a considerable amount to help with their care. Mr. Hebding has yet to provide any financial assistance for his children. The Hebding home is very small. It appeared to be very poorly constructed and unsafe for children. And I think it would be very difficult for 4 adults and 2 growing children to occupy such a small, cluttered space comfortably. Most important, and what I consider to be something that's very extremely important, is Mr. Hebding's, what I understand to be at least a 20-year on and off again criminal history. His explosive temper and his abusive behavior would make him unsuitable to raise children. When they lived in Portland and also New York, I understand the police were called on frequently to their residences. Substance abuse was an ongoing problem for both parents. And since my daughter never pressed charges on any of what we understood to be physical incidents, there's no accurate record of these altercations. I think Gabriel and Celeste should remain in our care with their mother and siblings present until Lindsay is able to provide them with a loving, stable home. And if the court decides that reasonable supervised visitation in Washington state should occur at Mr. Hebding's expense, we would facilitate that. And at this point, I have to say that I would agree 100% with Ms. Farr, the guardian ad litem's findings. And that is all I have, Your Honor.
Thank you, Your Honor. This is a petition, Your Honor, for an emergency guardianship, and the testimony in the case and the questions asked by other counsel has seemed to center around the provisions of RCW 113185. Under that statute, it provides that the court may appoint a guardian of a minor who does not have a guardian if the court finds the appointment in the minor's best interest and either each of the parents consents or all the parental rights have been terminated, or there is a clear and convincing evidence that no parent of the minor is willing or able to exercise parental functions as defined in RCW 260904. And that has numerous, I believe it has at least 1, 2, 3, 4, I think 5, 6 things that could be considered. As this petition is for an emergency guardianship, I think that the court needs to concentrate instead on RCW 11-130-225, which provides that the court may appoint on petition, may appoint an emergency guardian for the minor if the court finds that an appointment of an emergency guardian is likely to prevent substantial harm to the minor's health, safety, or welfare, and no other person appears to have authority, ability, and the willingness to act to prevent substantial harm to the minor's health, safety, or welfare. We're not in a full guardianship to where the full issues over that are contained in 11-130, the previous one, the 185 provision. I believe that we're not currently under that provision, but should be looking at 11-130-225. In this case, as attorney for the children, and having heard all of the testimony, Your Honor, including the testimony and reading all of the documents, including Ms. Farr's original report, I would assert that there's more than sufficient evidence to reach a conclusion to grant an emergency guardianship under the 225 statute. And moreover, I think that there's sufficient evidence, even if we were looking at the 185 portion of the statute, that there's more than sufficient evidence to meet both statutes. Again, the petitioner outlined the final argument that was interesting because in in Ms. Estelet's testimony, she said she believed the guardianship should be granted, and I think she's outlined parts of these, because the children have been with them since 2019, been attending school, covered by insurance, and that they are healthy, happy, and thriving. When this incident happened in November of 2019, she testified that she went to New York. She flew out to get the children and bring them back, and they I believe, came back on Thanksgiving Day. She met with the social workers because there was a question as whether or not CPS was involved. She said she met with the social workers, was told that there was a proceeding that was about to take place. The social workers in the sheriff's office approved of her taking the children because she was concerned about taking them from New York, and that they thanked her for stepping in. The mother apparently continued to live in New York. Lindsay apparently continued to live in New York. And her testimony that we'll get to in a few minutes would kind of cover what happened while she was in New York, but she didn't arrive back from November of 2019. She did not come back and live with Linda, the petitioner, and her husband until March of 2022. There's a period of time that she was missing, not parenting the children at all during a period of time and was missing. Mr. Hebding, he was incarcerated, he indicated, for 8 months. And I believe he said July 20th of 2021, but I believe 8 months would actually have been 2020. But he was incarcerated a period of time, apparently didn't have any contact, real contact with the children until he wanted to do the visitation that kind of prompted this action. She said that when the mother got there in last March, she's been with them ever since, getting back together with their kids. But I believe she testified, and this is Linda, testified that it was in the best interest of the kids, that she thought staying with her and her husband was their best situation currently. She testified that the mother had mental health issues prior, but she was not aware of any treatment that she had gotten since that period of time. There was no discussion about whether or not the mental health treatment or the mental health issues continued after she lived with them or not. It was unclear from what I could tell. She went on to testify, this is Linda, that the mother, Lindsay, was not supporting the children financially. If they were to move out, if she was to move out with the children, which if there is no guardianship order in place, that's a possibility in this particular case. Even though mom is saying that she doesn't intend in the near future to move from the residence, it doesn't mean that she doesn't have the ability to and could move from the residence at any time that she wanted. If she moves, Linda said that she would not have the current capability to support the kids. As to the care currently, she testified that Linda and her husband currently take the children to school. Linda does most of the cooking, helps the kids with their homework, and indicated that she provides the majority of the care for the two children and help also with the eight-month-old twins. After Gabriel and Celeste came to live with them, she indicated that they got them on insurance. Gabriel had the dental issues that we've heard about with the cavities and needed oral surgery. It's going to need braces. And again, she outlined kind of that they're on insurance. There is some other expenses not covered. And that Celeste has the same issues and probably will need braces also. She did take Gabriel to counseling because there was a concern over the incident from November 2019. She did take him to counseling, and that was covered by their insurance. As to Mr. Hebding, I believe Linda testified that she did not think the father is a capable person to parent the children, that based on the incident in November, the stabbing incident, and incidents of alcohol and other drugs in the children's presence and ongoing criminal incidents that she's aware of, that would not make a suitable parent. Again, she indicated in closing argument she had received no support from the father. He had sent some gifts, and I believe the computer that they used to chat on. Linda did also acknowledge that she was aware that Lindsay had past issues with alcohol, marijuana, and other drugs. On the positive note, she did indicate that Lindsay does not have the issues now, and I think it was important that her statement says, in part due to living with them. She testified that Lindsay is thriving currently. Mom is thriving currently, but was not thriving when she was not living with them. She told the court, I believe, again in closing argument, that she believed it's in the best interest of the children to grant the emergency guardianship. Mom, I think, Lindsay, said that she had met Mr. Hebding and he concurred that they met in 2012. That from 2012 to 2019, she indicated that the relationship between them was okay for the most part until the issues that started when they moved to New York. She had issues apparently of not getting to spend a lot of time with the kids because she had to work longer. That they both started drinking too much, ended up getting into some arguments. Nothing, she said, nothing major until the incidents that happened at the end of the year there. Both of them drank before moving to New York with no issues, but that escalated when they moved to New York. She very rarely used marijuana. That he was using marijuana, he was a daily user, and it continued at least through 2019 when they were not together. She did use other drugs, at least on one occasion that she indicated. The indication was that once they moved to New York, at least that parts of the drinking were occurring in front of the children. She indicated that they only smoked marijuana when the children were asleep and said something about being outside. In regard to the November 16th, 2019 incident, I think what is important is she told the court that she testified that they were involved in a physical dispute, had earlier been involved in a physical dispute prior to the November 16th incident. Police were called, alcohol was involved, children were in the house at that point in time and were asleep. And regarding to the November 16th incident, she indicated that she and Mr. Hebding had been having a rough day prior to the stabbing. They had been arguing, but the argument had not turned physical. In contrast, I think it's important that Mr. Hebding testified that they had not been arguing that day. She went on to say that the parties had not been getting along that day. She remembers music playing on the television, being on the couch with Celeste when they started, they meaning Sean and Mr. Hebding started shoving each other around and stuff. There was some talk about money being owed. And I think more importantly, she admitted that everyone was, I think in her words, a bit intoxicated. She indicated that both children were present. She's indicating Celeste was in the living room. Gabriel was in another room, doesn't believe he was interviewed. Would be surprised if he drew any type of picture of what happened. Maybe it was of the aftermath, I think was her testimony. She did take Celeste out of the room, called the police, and I believe indicated that they were contacted by a CPS worker who were looking into the case, but they didn't say anything about taking away the children. She contacted Linda to come and get the kids because she didn't have anyone there that could take them. She went on to describe Mr. Hebding kind of as a stay-at-home dad in part because he had been injured. He was receiving disability benefits. She was the breadwinner of the family up until the time that they separated, and kind of had outlined that better to Ms. Farr. Mr. Hebding, I think, indicated that he did have issues with alcohol. Drinking did increase in New York, and that he, after getting out of jail, or since the day he was placed into jail, has not drank. He does admit that since his teens, he has been a marijuana smoker, so he has been a smoker over 20 years. He does currently use marijuana. The interview with him, which was back in 2022 by Ms. Farr, I believe she indicated that he told her that he was smoking daily. I believe he indicated currently that he was smoking 3 to 4 times a day. He had reduced it to 2 to 3 times a week. And that has been for a couple of years now, I believe was the testimony. He apparently indicated he had a medical marijuana card in Oregon, and that he didn't get a medical marijuana card in New York that continues to use. Before the 2019, he said that no incidents that came up with the children needing state intervention. However, he did go on to describe, and I think this was also in testimony by, possibly by Lindsay, that there was an issue because they had alcohol in the house. they had Lindsay's 17-year-old daughter, I believe it's Madeline, they came to live with them. And there was an incident where Madeline got into the alcohol that was being kept at the house, and that ended up pushing Gabriel. And I believe Mr. Hepting said Gabriel had hit his head, and I think described it as cracked his head open. So there was an incident prior. At the time, they were living in what was his parents' home. Currently, he lives in that same home with an uncle. There were some questions about whether the condition of the home. He indicated that when he came out of jail, he had kind of fixed up the house. Prior to that, it had had some major water damage. I think what Mr. Hepting's position is that he's able to take care of the children at this point. He indicated he could provide a loving, stable, nurturing home, could feed the children, clothe them, provide them personal care, make judgments about their care. He said he provided all of those services prior to 2019, that he was the majority of the cooking and cleaning, taking Gabriel to school and helping with homework. It's interesting that Ms. Farr, as part of her investigation, did talk to the mother, and the description of what was happening in the household was quite different than that. And according to Ms. Farr, the mother told her that she basically came home at the end of the day working and had the majority of the care for the children at that point in time that they needed. That her oldest daughter babysat for the kids when she was at work for parts of the time, because Mr. Hepting would drink alcohol, get sick, and basically other times just play video games in regard to children's care. He is currently described as disability, indicated that he, I believe, has issues with a leg, with foot. I believe he has some back issues. They're kind of explained that they're kind of extensive injuries. He said that his injuries prevent him from staying on his feet for a long time. It's messed with his back. Some days he wakes up, his foot just doesn't want to work. And on those days, he can't do too much. It was interesting that when he was asked about how he supplied marijuana, or how he gets marijuana to smoke, he indicated in New York that he wasn't buying marijuana on a regular basis, but he has a friend that gives him some from time to time. Describes a friend as a person that he goes hiking with. Complaint to the mom was that he was on disability benefit. She believed, I believe, I told Ms. Farr, she believed that he was employable, but he was not working. He had not worked up until DoorDash, I believe he indicated, since before 2012, was the last time he held a job. As far as the medication usage, he indicated he does not use oxycodone daily. Ms. Farr said that her notes reflect that's what she was told when she interviewed him. He indicates that he has 30 pills, which would last 3 to 4 months. He is also on Flexerol, a muscle relaxant, on 2 times a day. I believe he said morning and afternoon, or morning and evening. And he's also on gabapentin, which is, I believe, for nerve issues potentially related to the injury. As far as some of the issues I think that are present, he described an incident that there had been only, at one point I think he responded that he can remember only one instance of domestic violence in the relationship with Lindsay. However, I believe when I asked him, indicated during their relationship, there's only been 2 times he can remember that an argument had turned physical. He said the prior incident, one of the prior incidents was an argument that resulted in physical contact. Both children were in the house. He believed at the time they were asleep. In regard to police contact, in part related to Lindsay, he indicated that police had been called one time before after a long night of Lindsay drinking. It was the night after an argument, and by 9 or 9:30 in the next morning, he had called his parents to come take them to their place, that he had not been drinking. He said Lindsay called the police because he was taking the children away. He also said, in describing the incident on November 16th, he indicated that he did stab Mr. Sorensen. He didn't but he said he really didn't he didn't really assault or attack him either. I'm not sure what that meant. That it occurred inside the home. He and Lindsay, the children, and Madeline were living at the home at that time, and I believe all were present. That he was drinking prior to the incident, had not used marijuana that day. That Celeste was in the living room with Lindsay. I think he indicated he didn't believe Gabriel was in the room. On questioning, he admitted that alcohol played a part in the incident. He took offense at the fact that the statement that was made, that was alleged that he made to the police about having, if he had a gun, he would have shot Mr. Sorensen. And I believe he responded that they had put words in his mouth for that report. And he had a copy of the report that was attached to the guardian ad litem's report. While in prison, he was, I believe, in jail actually for 8 months. While there, he completed a parenting group. And when asked, I believe that was a 5-week program. It met 1 time a week. So he had 5 sessions of a parenting group. He had a healthy living program while he was in jail. That concentrated around grief and loss. That was a 5-week program where they met once a week. When Ms. Farr asked for additional information to verify those programs, he told her apparently that she should get that information herself. He is not, what's interesting is he's not completed any other programs. He indicated he did go to AA for a little over a year, not currently going to AA, has not had any kind of anger management, has not had a domestic violence evaluation, hasn't had a substance use evaluation or a mental health evaluation. When asked, I believe by counsel, and I think this was originally Mr. South, a question that related to possibly what he wanted to see in this case. And I believe he indicated if the parenting plan, if the guardianship, emergency guardianship plan is denied, his plan was to create a reasonable parenting plan with the mother, which acknowledges that he is able and willing and no danger to the children, and to take care of them in New York. When asked, I think he said the issue of whether the children should be sent back to New York would be determined in the parenting plan. His intention, he indicated on the day of the hearing, was to get rid of the guardianship so he and the mother can work on a parenting plan. Said the ideal parenting plan, I think in response to one of Mr. Gooday's questions, was the ideal parenting plan is to have the children who would stay here to complete school, then go to him in the summer, and then return shortly before school, and then to alternate holidays. So his plan would be to have at least 2.5 months or so during the summer. I think there was an issue with both Linda and Lindsay because guardianship, in this case, emergency, was started in part because Mr. Hebding, when there is no parenting plan in process, Mr. Hebding wanted to take the children on the national park tour, and they were concerned because they did not believe Mr. Hebding would bring the children back. I think that when asked about what they wanted to see for some type of visitation, if this is granted, I believe that still was the concern, maybe not so much in part of Lindsay, but I think that is a concern of the petitioner and continues to be, was whether or not he would, if he's giving unsupervised visitation, whether he would bring the children back. I think Ms. Farr's report, Your Honor, summarizes it. I think that the issue in this case centers around several things. There was a discussion concerning the fact that she did testify that the petitioners have had the children since 2019. Her notes indicated, Your Honor, and she testified that her notes indicated that the mother had been in an alcohol coma, was unable to take care of the children, and that subsequently the petitioner went to New York to get the children. The father had had little contact since jail, getting out of jail until the vacation was requested. Again, said that she was told about kind of how the household worked prior to 2019. She indicated that, Ms. Farr indicated that she doesn't believe that the mother was ready to independently parent the children. She's good with helping with the care of the children. But the concern was if the guardianship was terminated, if she was to have custody, she was no way able to independently provide financially for the children, for the financial care and shelter, for the reason that the financial care and shelter is currently being provided by the parents, that the mother, and I think this applied to Mr. Hebding also, that the mother doesn't have a full awareness of the DV incidents and the November incident and what impact that had on the children. Father, she testified, Ms. Barr testified that father has never raised the children on his own, was a stay-home dad. Again, kind of gave details that Lindsay had said about dad's care, and the fact that Lindsay didn't find the dad to be a patient person when he was watching the children. She testified that the 2019 event is a significant event, which would require some sort of evaluation and treatment on behalf of the parents. The children witnessed that incident. Neither parent has an awareness of how that really affected the children. Bottom line was that she did not think that either parent is able to properly parent the children and protect them and keep them safe, and that the emergency guardianship should be in place while there is some evaluation and treatment and a parenting plan put in place before any consideration to either terminate the guardianship or until the guardianship runs out. That the father did indicate, she heard the testimony, father indicating that she wanted summers, but there was no guarantee that he would return the children. There was a bit of discussion with Mr. South and Ms. Farr over whether or not the mom, by going to Linda's house, whether their financial support of the children and their care of the children, their providing the medical for the children, was satisfied some of the requirements in the 29 or 2609-004 provision. And I believe that it centered over the fact that Mr. South was trying to get Ms. Farr to say that she believed by taking the kids or having the kids taken to Linda's house, that satisfies the parental functions that are required in at least the 11-131-85 that references the 26th section. I don't believe that that's the case. I don't believe Ms. Farr did either. I think that the person, both parents have to be able to independently parent the children. It would be nice if that were the case, because we'd have a lot of guardianships where guardianship would get filed, people would drop the children off with the parent, for the parent to support, to care for the majority of the time, to provide medical, provide all of the financial support, to provide the house, to provide the food, and say, well, I completed my parental functions. I don't think that that's true. I think what was interesting, because Your Honor did ask Ms. Farr here, she had several times that the mom, and I think this applies to both mom and dad, there's been no recognition of the impact of domestic violence. And then Your Honor asked her, what would you be looking for? Or what is it that you are not hearing that leads you to that conclusion? And I think it applies, even though it was asked about Lindsay, it applies to both parents. Her answer, Ms. Farr's answer, was that she is not hearing any admission of responsibility, of awareness of what the children have gone through, how it's impacted their mental health. And in particular to Lindsay, it says when she talks with her, it seems like it's over and it was a one-time thing. There's not an awareness or recognition of how significant that one event could impact the children for the rest of their lives. We had some testimony from Deputy Brewer, or from Ms. Farr, about statements made by Deputy Brewer. And we realized that those statements, the court limited those statements to the purpose of how it impacted Ms. Farr's opinion. But the statements that she related that were made, not for the proof, but for the fact that they were made and that they were taken into consideration, was the fact that whether Gabriel was interviewed and what Gabriel had seen. And I think what was significant was that she indicated that there was part of her investigation was that she was told that he had drawn two pictures, one of them with his father with angry teeth. This is out of the November incident, and one of the other gentlemen with a knife impaled in him. That's the kind of impact we're looking at on the children and what lasting effects that has. What have the parents done to kind of address those situations. When asked, I think when I asked her, she indicated that based on her education, this is Ms. Farr, based on her education, training, and experience, along with the information and documents that she obtained in her investigation, it was her recommendation that the emergency guardianship be put in place. She said there needs to be some mental health evaluations and domestic violence evaluations, along with treatment for either. Once parents have completed those and are able to parent, then a parenting plan should be put into place. The concern was, one of the concerns is, why hasn't a parenting plan been proposed or put into place? The indication was that Ms. Farr testified she had spoke to Lindsay in August of 2022 and had indicated that, that was potentially important that a parenting plan be put into place. Since that time, nothing has happened with it. She did speak to her, I believe, the day of the hearing, the morning of the hearing. Lindsay told her at that discussion that she was still working on it. Lindsay, I believe, was to the opinion that she was only told about potentially having a parenting plan more recently to sometime prior. But Ms. Farr, I think, notes have indicated that she spoke to her in August of 2022 and has spoken to her times since that time, and that nothing has been accomplished in regard to a parenting plan. Without that,
Angelica, we need to wrap up in about 2 minutes.
With that, Your Honor, Mr. Hebding is able to come and secure the children if he wished without a parenting plan and without an emergency guardianship. Don't believe, along with Ms. Farr, that that's in the best interest of the children. We would argue that that does satisfy the basis for the guardianship, an emergency guardianship under 11-130-225, that the appointment is likely to prevent substantial harm to minors' health, safety, or welfare, and that no other person has the authority, ability, or willingness to act. In this case, I think the more important one of the three, I think, is ability. They both say that they're willing to do that, but I don't think that they have the ability to prevent substantial harm to the minors' health, safety, or welfare. We also believe that we meet 185 if Your Honor is using that statute, but I think that that also shows, with all of the evidence that's been presented, that neither one of them are able to effectively parent, and that it's in the best interest of the children to grant the emergency guardianship for the 60 days, during which time, hopefully, a parenting plan a petition for a parenting plan can be filed, that they can gain all of the evaluation and treatment that they should have had in place prior to now, especially in regard to Mr. Hebding and any type of anger DV issues given the November 2019 incident. Thank you.
All right, thank you.
All right. So this case this guardianship should never have been even granted the emergency one. Admittedly, by the parties, by the petitioners, this is a situation where they petitioned for this guardianship because they were concerned that the father was going to have visitation and keep the children, not bring them back. And so this petition was basically just a way to circumvent the Parentage Act, RCW 26.26. And that's not the purpose of the guardianship statute, is not to restrict any kind of visitation on one of the parents, put the other parent in a better position. Now, pursuant to RCW 132.25, I think it's clear that both parents have the authority and the willingness to act in these circumstances. So let's go back to the testimony. Linda Estelet stated right off the bat, one of the first things she said, that Lindsay can fulfill her parenting role. She may have said that she needs help. Every parent needs help, but she did say she can fulfill her parenting role. And we went through the parenting functions that are set forth in RCW 2609-004. And Linda Estelet, the petitioner, said the mother can provide a loving, stable, consistent, and nurturing relationship with the children. She did state that the mother can provide for the daily needs of the children, such as feeding, clothing, etc. There's a few more things in there. And she can exercise appropriate judgment regarding the children's welfare. That alone would make the guardianship, so that the guardianship should be denied. So then we get to the financial support. That's another part of the 2609-004. We argue that the mother is able to provide financial support for the children by residing with their mother and stepfather. It's not any different than a parent applying for TANF. It's not any different than the millions of people that rely on having a significant other to be able to, pay the bills, pay rent. They're not independent. They're relying on either the government, relying on a significant other to help. And so many people rely on their families to help support. That's nothing rare. There's nothing in the statute that says they have to be independent. They have to go out and get a job. They have to get a job that pays enough to pay for daycare for 4 children and still thrive. That would be an absurd reading of that statute. And we'd ask the court not to read it that way and interpret it that way. So Lindsay's going to continue to reside with her mother and stepfather. There's no indication that she's going to move. There's no concern that she's going to take her 4 small children and move out and live on the streets. And I guess Mr. Angelico and the petitioner are asking the court to rule on a very, very unlikely hypothetical that Lindsay's going to move out, take the kids, and not have any financial support. That's just not going to happen. And the court just cannot rule on a 1 in a million shot hypothetical that something like that's going to happen. And if it does, of course, there's options to file another petition, but that's just not going to happen. The court shouldn't consider that's even a chance. In regard to the whole GAL report, it's clearly biased. We'd ask the court not to consider it, actually consider how biased it is. The GAL role in this is to be an independent party, I guess an independent actor for the court that provides information so it doesn't become a he said, she said. The role is not to become an advocate for one side and then clearly skew their report to support their position, the GAL's position, and actually withhold evidence. In this case, Mr. Hebding provided those certificate of the classes to the GAL. She held them. She did not provide them to the court. She actually wrote under penalty of perjury that there's no verification that he took those classes. She put herself in the judge's shoes. She determined she was a finder fact. She found that those things weren't worthy of the court's attention, and that's not her role. I could go on in length about the GAL report and how biased it is, and I'd ask the court to consider that in making your ruling. So Mr. Angelico went on in length about the mother and father's past, particularly the father. We suggest that that's not relevant. It's only relevant in how it pertains to potential safety of the children. There was no incidents where either parent actively put the children in harm's way. They're asking the court to rely on the fact that the parents had problems in the past. Really, they had very little problems in the past compared to what this court usually sees. Mr. Hebding had the situation in 2019, and Lindsay Estlet had the situation where she had this kind of temporary mental health issue that has resolved itself. But other than that, there wouldn't be any basis for grounds for a guardianship. They had some ups and downs, sure, but not like what this court used to be seen. What the court needs to do is focus on the present. That's what we're looking at. If the court were to focus on the past behavior of parents in these situations, none of these guardianships would ever go away, because to get in this situation, every parent has had a really checkered past, more so than this in these two parties. We're looking at where these people are right now, and they're both seem to be in good places, with Lindsay living with her parents, taking care of the kids, and Mr. Hebding is cleaned up. He's clean and sober. Hasn't been any more problems. Looks like he's beginning to work a little bit more, something he's able to do. He does get his disability. Nothing there shows that they aren't able to provide the parenting functions. I think the petitioner, Mr. Angelico, and the GL are all using the wrong standard in looking at this. They are looking at the best interest of the children standard. And that's not the standard. That never has been the standard in guardianships, and even in the past non-parental custody statutes. It's never been what's in the best interest of the children. It used to be if the parents are unfit. Now it's they use a different term, just calling it providing parenting functions, basically the same thing. So the fact that the kids are doing well in school and they're going to get braces, and perhaps the parents can't provide the braces for them, that's not the standard the court uses on this. The court can't use that standard. Whether that's right or wrong, as we used to say, Bill Gates doesn't get every kid in the world because he can provide for them better than anyone else. You just have to show that the parents can provide that parenting function to be able to grant the guardianship. and that's not the case here. And you also need to look at the effect of denying this guardianship. What is going to change? Nothing. The status quo is going to remain in effect. Hopefully, the parties will work on getting their Parentage Act going and getting a parenting plan. But nothing's going to change on this. They talked about the impact. The GAL talked about parents' lack of dealing with the potential hypothetical impact that the 2019 incident had on the children. Well, what is that impact? Ms. Linda Estelette said the children are fine, happy, doing well, everything's great. Where's the impact? Where aren't they supposed to be doing poorly in school if this is has affected them so badly? Aren't they supposed to be acting out? None of that seems to be happening. I think at that point, in her testimony, the GL was kind of back on her heels and reaching for straws for something to support her position that the children should stay with the petitioners, again, because she thought it was in their best interest. Whether the children need that or not, we don't know. There's no evidence to show that they've been acting out, that this has severely affected them. And if it does, who's to say the parents won't address that? So I don't know that the court could consider that, this lack of consideration, I guess, that for a situation that hasn't arisen yet. Mr. Angelico argued about neither parent has had any assessments for drug and alcohol use, mental health use, domestic violence, pretty much the laundry list of assessments. Again, any domestic violence incidents, Mr. Hebding's incident of 2019 was not a domestic violence incident. There may have been some incidents in the past, but nothing that there was any arrest or any convictions on. No requirements to have a domestic violence evaluation. A mental health evaluation, I don't know where that comes from, because there's no indication of Mr. Hebding's part that he's had mental health issues. And Lindsay did testify that she did have some mental health, and the mental health and no more was needed. My client is clean from alcohol since 2019. He does use marijuana occasionally. He does take some prescribed pills. Nothing to indicate that he has some type of serious problem that needs an evaluation and any treatment. No evidence that Lindsay has any type of serious problem that needs an evaluation and treatment. So again, I don't know if the court could consider the lack of having assessments that aren't needed is the basis for granting this guardianship. There's no guardianship needed here. It's almost, well, the fact that they're all living in the same household in and of itself probably means there doesn't need to be a guardianship. Lindsay's always there. If they need to sign a doctor's note or a teacher's note or something, she's there. I don't know the need for a guardianship. The guardianship was based on kind of a faulty position in the first place and just a way to circumvent the parenting plan. And for those reasons, I'd ask the court to deny the guardianship.
All right. Thank you, Mr. South. Mr. Gooday?
Yes, Your Honor. Thank you. Judge, I'm just having a hard time trying to figure out what the emergency is here. It's an emergency guardianship, but everything seems to be fine. The father didn't say he was trying to come take the kids. Lindsay didn't say she's trying to take the kids. Seems like everybody's fine with things as they are. They just need to figure out some visitation rights for the father. But I would agree with Mr. South that there's no emergency. This is kind of on a hypothetical situation. Well, what if mom does try to leave? But it doesn't seem like that's the case here. That just seems like a way for grandma to try to establish some custody rights. But there's no emergency, so this doesn't seem appropriate. It seems like this should be in the family court where parties are talking about custodial rights and parenting plans and visitations and things of that nature. So because neither of the parents are trying to take the kids and because everything's fine and there's no emergency, seems like the guardianship is unnecessary, Your Honor. And I'd ask you to deny it, please.
All right. Thank you.
Thank you, Your Honor. In regards to the children's emotional and mental health, when they first got here, there was a lot of issues with them. We addressed that with the behavioral health personnel through our insurance. They're comfortable with us. We had a very good relationship before they moved to New York. So they were just right at home. They were here quite a lot of time when they were living in Portland. So they knew us, they felt our love, and we cared for them as best we could. Loving support and our willingness to listen, because at first, even little Celeste, who was between the two men when the stabbing occurred and got covered with blood,
Your Honor,
even that.
Your Honor, if I'm going to object right here, maybe you could address with Ms. Estolette that this isn't the time to provide new information, new evidence.
It's not new. It was in the proceedings. It was in the pleadings, the petition. But anyway, they're comfortable with us here, and so they are thriving. Neither parent showed up until about 3 years, maybe a little more, after the incident in 2019. I don't know what their priorities were, but that is the case. We were taking care of the kids. We want to protect them from any further harm. And I would ask Mr. South if he's ever heard the quote, "If you don't learn from the past, you're doomed to repeat it." With people with extensive criminal histories, sometimes that is still the case. That's all I have, Your Honor.
All right, thank you.
You're welcome.
All right, first of all, I want to thank all of the parties and the attorneys. I think you did an excellent job of presenting the case, and as is often the case, because that was done so well, it helps the court determine the decision. If there's any confusion that this matter is governed by RCW 11-130-225, if you look up that statute, I'm going to quote it in a minute. This sets forth the requirement for an emergency guardianship. An emergency guardianship is good for 60 days, and it can be renewed for another 60 days, and after which there's no provision in the statute for it to last any longer than that. The section RCW 11-130-185 is the provision to grant a full guardianship, but that's not what we're here for today. The emergency guardianship statute indicates that the court may appoint an emergency guardian if the court finds, and I'm quoting, "no other person appears to have the authority, ability, or willingness to act to prevent substantial harm to the minor's health, safety, or welfare." So breaking down these elements, and first of all, these elements have to be proved by clear, cogent, and convincing evidence. Breaking down those elements, the first one is who has the authority? Well, certainly the parents have the authority to care for Gabriel and Celeste. I think the question that we're focusing on today is, do they have the ability to prevent substantial harm to their health, safety, and welfare? And I'm going to take those each separately. As to the health, the evidence is that when the children came to live with Linda Estolette, Gabriel had significant dental work that he needed due to cavities, and that resulted in oral surgery. That seems to me on a young child to be some evidence of the neglect of care as opposed to just a normal process of cavities forming, to have it to that extent. There was evidence presented that the living conditions in New York, and this is from both Linda and Lindsay Estolette, that they were not conducive to having children living there. Neither parent is in a position right now to provide medical insurance for the children. All of the medical insurance has been done through the proposed guardian. And I will note that as it relates to the dental care, the proposed guardian's share of that treatment was over $1,600. The guardian has made a point that I think is valid, which is that given the circumstances that the children have gone through, which is both the domestic violence at the house and the November 2019 incident, that there needs to be some sensitivity about that. The guardian, I think, has shown that by having some counseling, but the guardian ad litem did not see that sensitivity in either of the parents. So there's a significant question as to whether the parents can adequately care for the children's health at this time. As to safety, the evidence is that while the parents were together, the children observed domestic violence, which in Washington is considered domestic violence directly against the children. There's the issue of stabbing, where at least Celeste observed. I will note this issue is improving. The father has shown that he's attended parenting classes. The mother does not appear to be a risk presently, but the history suggests that more evaluations and perhaps treatment by the parents is necessary to ensure the children are safe. As to welfare, the evidence is that neither parent has contributed, at least not substantially, in a financial way to the children's needs. I don't think relying on the fact that you live with your parents and that is the way you provide for your children is sufficient. While living with the parents, a child or the mother of the children we're dealing with here could have a job. They could obtain state medical for the children. They could be going to school to develop a career. I understand in this case, there are twins in the picture, but there's just no evidence that the mother has taken any steps to function independently. Further, there's been, except for a computer apparently, there's really been no contribution by the father. And even more concerning to the court is there's no plan that was discussed during this case as to how the father would financially support the two children. So based on that discussion, I find that there is clear, cogent, and convincing evidence that the parents at this time cannot prevent substantial harm because they cannot provide for the children's health, safety, and welfare. So I'm going to grant the emergency guardianship to Linda Estelet for 60 days with the potential to extend it another 60. As to the evaluations, I'm going to talk about this in a minute. I'm going to defer any evaluations to the family court. In granting the emergency guardianship, I don't think that's the end of the discussion. As I've indicated, I think the parents are making strides, and I want to acknowledge that. The father has maintained contact with the children through Zoom. And as I said, he's done parenting classes. And I think it's important to note he has shown up at every hearing in this case and is obviously interested in being part of his children's lives. So I want to acknowledge that. The mother has had daily contact with her children, assists in taking care of them. And so I believe both parents are moving into a direction to where the guardianship may not be necessary in the future. What I would like to see is for the mother, because the children are living out here, the mother should begin a parenting family law action with the Cowlitz County Superior Court. In that action, I would expect the court will adopt a parenting plan, which will discuss how Mr. Hebding will be able to see the children given the distance between them. That court will also, if it feels necessary, order the various evaluations that have been discussed by Ms. Farr. When the parenting plan is in place, then I think we may be able to revisit this case and determine whether that's the right time to end the guardianship or whether it needs to go on farther. In the meantime, should Mr. Hebding come out to Washington, I would like, and I'll allow visits, I think, for right now until we have the assessments in the parenting action, those visits should be supervised. But I would let the parties arrange for that. I would hope those visits would be during the day, at least 6 to 8 hours during the day. So that will be my decision. Again, I want to emphasize, I think the parents are both moving in the right direction. I don't see this guardianship as something that needs to last forever. I think it needs to be in place until, till the family law court determines what it needs to set up a parenting plan. What was that?
The court's going to do the order?
I've got an order here. Let me take a look at it. All right, on the first page, I indicated that I granted the order on page 6. I've indicated that letters of guardianship will be issued for 60 days. That'll be till June 26, 2023. I'm setting a review hearing for June 22nd. I have removed on the temporary restraining order, I've removed the do not disturb and stay away provisions. I have left in that the children shall not leave the state of Washington with Mr. Hebding. And I think that's it for now. Let me sign it.
That was the 22nd of June?
Yeah, the 22nd of June.
I have an additional question, Your Honor, as well as others may have.
Okay, so let's have some questions. Go ahead, Mr. Angelico.
As the emergency guardianship petition is in place, Your Honor, there's been no full guardianship filed. I believe I would be asking the court to enter a bench order that allows myself to withdraw as counsel for the children.
I will allow that. Let me just make a note on something here. Ms. Farr, did you have a question?
I do. And so same question, am I discharged or is my involvement still going to continue through the review hearing?
There's no full petition at this point. I think discharge would be appropriate.
Okay, so then should I submit?
You want to submit that paperwork along with your statement?
Yes, thank you.
Okay.
Your Honor,
Ms.
will
Escalante.
we have copies of that order sent to us, or how does that work?
They won't be sent to you. You could come up to the court tomorrow morning and get a copy of it.
Okay, thank you very much.
And tomorrow morning, just because we need a half day to process it.
Okay, that's fine. Thank you.
In your honors, should I be filing a motion to withdraw as well, or should I be staying on?
No, I think you can withdraw too if you'd like. So
right.
Why don't you file a motion on that?
Thanks, Judge.
Yeah, will a copy of that be sent to me, or do I need to call the court?
It won't be sent to you as a matter of course. So if you call the court, they might be able to scan it and email it to you.
Okay, and
I'll see what I can do.
okay, thank you, Timothy. As part of the order, does that include my guaranteed Zoom visits?
I didn't put that in there, but I think that's a fair statement.
Prior to this
So
case.
under
Okay,
section 14, I'm going to add Zoom visits as agreed by the parties.
Your Honor, I'd ask that be more specific than that. If they never agree, they're never going to happen.
Well, they're happening now. I'm not. What would you like, Mr. South?
Just consistent to what they were in the prior order.
Any other questions?
No, sir.
All right. Thank you, everyone. Again, I appreciate everybody's hard work on this case.
Thank you.
Thank you, Your Honor.